Good evening, everyone. Lady Chief Justice, distinguished members of the judiciary, members of the MacDermott family, distinguished guests, colleagues, friends. My name, for those of you who don't know, is Professor Joan Knockery, and I'm head of the School of Law. And on behalf of my colleagues, it's a great pleasure to give you the warmest of welcomes to this very significant event in the calendar of our law school. Before we begin, I need to give you the housekeeping news that we're not expecting to be interrupted by the fire alarm. Should it sound, can you please leave your personal belongings behind? Please exit by the doors that are marked. I feel like an air stewardess. Please please leave by the doors that have got exit signs. Make your way down the stairs to the assembly point outside the front building. Please don't re-enter the building until we're given the all clear. Now, that's something that we didn't miss doing during the COVID online presentations. But turning to the serious business of the evening, this annual event is an event to honour Lord MacDermott, a most distinguished alumnus of this place. He was a law teacher and judge of international standing. I'm going to give you a little bit of background about Lord MacDermott. After service in the First World War, which saw him awarded the Military Cross, he enjoyed a successful academic career alongside a high-profile practice at the bar. Having taken silk in 1936 and a parliamentary seat in Northern Ireland in 1938, he was appointed Attorney General of Northern Ireland in 1941 and a High Court judge 3 years later. In 1947, he was appointed Lord Appeal in Ordinary, and subsequently Baron MacDermott Belmont returned to the bench in Northern Ireland as Lord Chief Justice in 1951, an office in which he served with considerable distinction until his retirement in 1971. Here at Queen's, we take justifiable pride in this legacy and in his contribution to the university as a lecturer in jurisprudence and as Pro Vice-Chancellor. And we also continue to acknowledge and celebrate his lifetime of exemplary public service. This lecture series itself was inaugurated in 1972 to mark Lord MacDermott's retirement as Lord Chief Justice. And as many of you will know, our custom in framing the occasion is to return to Lord MacDermott's terms of reference for the series that were delivered with characteristic rigour and clarity in the inaugural lecture that he himself delivered in 1972. And there he made the following observations about the relationship between law and society and the importance of subjecting our key organising concepts to close scrutiny. He said, "We know from the history of law and its institutions, the vitality and fortunes of a people are closely linked with the quality of their laws and can ebb and fail if these cease to be effectual or to serve the requirements of the society they purport to rule. And knowing that, it's only prudent that we should, from time to time, scrutinise the health and condition of our principal legal concepts and mark any trend or sign which might injure or imperil the common weal." We're deeply honoured tonight. This scrutiny will be undertaken by Professor Devyani Prabhat. It's my pleasure now to invite my colleague, Professor Aoife O'Donoghue, to introduce Devyani. Thank you.
Thank you, Joan. I'm very, very pleased to be able to welcome Professor Prabhat to Belfast and to Queen's University for the MacDermott Lecture. Professor Prabhat currently holds a post at the University of Bristol Law School, as well as having a legal practice in constitutional law. She's a specialist in socio-legal work and comparative work, and particularly, as she's going to talk to tonight, on immigration, citizenship and constitutional law and the rule of law specifically, as we're going to discuss tonight or here tonight. Her very deep knowledge and understanding of these areas and her ability to combine a variety of perspectives and insights is very clear in her extremely extensive publication record, including her Brooks Prize winning monograph, Unleashing the Force of Law, Legal Mobilization, National Security and Basic Freedoms, which is an excellent book, which I returned to yesterday in preparing the remarks. And even if it's not your area of expertise or interest, I would recommend even reading the introduction, because I think it brings really home the force and necessity of looking at these questions in depth. Alongside, she has her recent book, Britishness, Belonging and Citizenship, and an upcoming edited collection called Children's Rights, Foreign Fighters and Counterterrorism. Professor Prabhat also works extensively with activists and practitioners across a wide variety of countries and in very different contexts. And she has used that experience to innovate in her legal and academic publishing, including her book Citizenship in Times of Turmoil, Theory, Practice and Policy. And that book really demonstrates I think the importance of academics working with practitioners and with activists in order to get a full picture of the way that law works in specific contexts, and the importance of thinking about it deeply and from multiple perspectives. She also contributes to public debate very regularly, especially on issues on immigration, and I would recommend she has quite a number of pieces on the conversation that I would recommend to you all. And these are always very thorough and I think quite compassionate, including issues around the continuing Shamima Begum situation and the way that law in its current form reacts to that sort of scenario where somebody ends up outside of citizenship and law. I've heard Devyani speak, luckily for me, many times, and I've always come away better informed and much intellectually richer from that experience. This is particularly, I think, the case with Devyani because she is also an excellent storyteller, and she combines that rare skill in law, which unfortunately we all don't have, alongside her intellectual rigor to bring forward a legal story that is often at the core of how we think of ourselves, how we think of the society we live in, and what kind of society we would like to be. Her lecture this evening is entitled The Rule of Law in Immigration, Nationality and Asylum, and I'm very, very much delighted to pass over to her now, so welcome her up.
Thank you, Aoife, for the very generous introduction. Thank you, Joan. Thank you to all of you for coming and attending this and for inviting me to talk on such an important occasion in the honor of the legacy of Lord MacDermott, who himself spoke about the rule of law in his Hamlin lecture in 1957. So I've kind of drawn inspiration from that. And while I'm going to focus on immigration, nationality, and asylum, the core principles of the rule of law and what they're about are, it will resonate with the kind of work that Lord MacDermott himself did. So it's a real privilege to be able to do that. And also it's special to be back in Belfast 13 years back when I was writing my monograph, the one which got the Works Prize. I spent some time here in Queens, and colleagues here were tremendously generous with their time. So I have a debt to the institution and the city as it is. So it's a real opportunity for me now to kind of, to address you. Quite emotional about it, really. In terms of the topics today, I will cover the interstices, so not really in-depth asylum, immigration, or nationality, but the conceptual links between them. So between asylum and immigration, between nationality and asylum, and who is a settled person and how do they then suddenly lose that status and they become no status holders, who is a citizen, who is foreign. So these type of conceptual links, as well as differences between these and the challenges or impacts on the rule of law which arise from that. And I'll also have a little section in which I will talk about defending the rule of law. What are the challenges in that? But it is really about the stories in some way, the stories of the cases, the stories of the people. I do have slides, but that's just to give you some citations and extra information and some sort of a structure, but feel free to ignore those and we'll just go with the flow of the stories, really. So, but before we do that, we need some clarity on what do we mean by the rule of law. It's a really big question. Sometimes people say it doesn't really mean anything. It's a label. It can mean whatever you say it is. But I think I start from a quite a definite point, a really good point, which is Lord Bingham's work on the rule of law, from his famous lecture, which was a famous essay and then became an even more famous book. And he talks about the 8 key principles, which are really about the core of the rule of law. I think all of them are important and all of them are engaged in today's talk, but I will concentrate on 2, and I'll tell you which 2 shortly. But first, let me quickly take you through the 8. The first is the law must be accessible and so far as possible intelligible, clear, and predictable. Second, questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. This is one of the key ones that I will come back to quite often today. The third is the laws of the land should apply equally to all, save to the extent that objective differences justify differentiation. Fourth, ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. Very important, but not that much of a focus for me today. Fifth is the law must afford adequate protection of fundamental human rights. This will come a few times. Sixth, means must be provided for resolving without prohibitive cost or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. Seventh, the adjudicative procedures provided by the state should be fair. And eighth, the rule of law requires compliance by the state with its obligations in international law as in national law. This 8th principle I will consider a really key one for today's discussion. So the 2nd and the 8th are the focus of these various stories about the rule of law. I also draw your attention to a very famous section, the Constitutional Reform Act 2005, which in a very kind of negative framing says that the existing constitutional principle of the rule of law and the Lord Chancellor's existing constitutional role are not adversely affected by the act, thereby clearly indicating there is indeed an existing constitutional principle. At first, my first reaction when I used to teach this was to grumble a bit and say, why couldn't they assert this in a more positive manner? But now I like this more and more. I feel like it indicates it doesn't really matter if this section goes away from statute. It's existing. We don't, it's just declaring something. But essentially, the rule of law is part of the constitutional frame. And that's what is really important. And it's recognized there. So I no longer grumble about this anymore. So these are my 2 for you to look at, the ones about the exercise of discretion, how it should be about application of law, not the exercise of discretion, and the one about obligations in international law, as in national law. These 2 will be the focus of most of the things that I will talk about. So the first then is to talk about asylum and immigration. How are these 2 linked? Now, actually, asylum is supposed to be a matter of right. It is under Article 14 of the 1948 Universal Declaration. Everyone has the right to seek and enjoy in other countries asylum for persecution. It's quite clear, and it states it is a matter of right. However, with the recent legislative framework around this rapidly changing, we have had 2 statutes really to talk about: the Nationality and Borders Act 2022, which creates different tiers of asylum seekers. And now, if you're an asylum seeker who is arriving using so-called irregular means, which is really the mode of travel, it could be that you're arriving on a truck or you're arriving in a small boat, you will not be treated the same as someone who comes with prior permission. I do not actually know what that method would be, but presumably there is a means of getting prior permission and having a regular means of arrival. And they would be treated as a different tier of asylum seeker. So that introduces an element of discretion, which is not consistent with this rights framework. Also, we see now under the illegal immigration bill, which is in Parliament currently, it's almost nearly, I think, finalized now. What we see there is that now there are means to send them back to safe third countries, which is supposed to be by agreement with those countries. And Rwanda is an example that comes to mind because it's being discussed a lot at the moment. And it's possible then to send the people who do not have the prior permission, who have come in through irregular means of travel to those so-called safe third countries. And again, it becomes a matter of then discretionary assessment about their mode of arrival rather than the actual genuine claim and fear of persecution, which formed the basis of asylum seeking thus far. And what is interesting, so we are talking about principle 2 about discretion in the rule of law, but coming to the international law aspect, when this bill was introduced in Parliament, we see that both the Home Secretary in the House of Commons and Lord Murray of Blidworth, who was the minister in charge in the House of Lords of this bill, they make a section 19(1)(b) of Human Rights Act statement saying that they cannot guarantee that it's compatible. They're unable to make a statement. I think the exact wording is, I'm unable to make a statement that the provisions of this bill are compatible with the convention rights. So this is very, very unusual. The section 19 mechanism exists so that people reflect on it, and the minister can reflect on how whether it's compatible or not, but it's quite rare to actually say it's not compatible, but nevertheless we proceed. And I think there again, we can see the various gaps then between what was considered a sort of rights framework and how it's actually changing in operation through legislation. Another clear example, I think it's even clearer than the other example, is to look at the Ukrainian sponsorship scheme. This is actually a visa scheme where Ukrainians have to apply for visa. They have to find a sponsor, somebody who can provide them a home basically for 6 months. And so even though they are fleeing a war situation, in effect, they are seeking prior permission through this mechanism, which is a special sponsorship scheme, a visa scheme. And through that mechanism, they are being accommodated. Now, this has been presented as really enterprising in solving and assisting, and it has definitely helped a lot of people who were fleeing the conflict. But what is important is it makes the matter not a matter of right to simply arrive as you would expect if they are fleeing a war-like situation. It's not a matter of simply arriving. There is still all these different hoops to go through, the administrative mechanisms to go through, which render it, again, much more discretionary decision-making in nature. And I think it conflates the asylum process with the immigration process, which is actually about prior permission, visas, etc. So conceptually, both of them have come closer through examples like this. I shall not even go into the vulnerability of what happens with sponsors who are giving you a guarantee of only 6 months. I know there's a lot of media coverage on this. I'm going to stick with the theme of let's look at the interstices between these different concepts. And now I'm going to talk about how nationality and asylum can get conflated into one. And I'll do that through the story of the East African nations, for which we have to actually go back to 1948. Now, why this sudden leap into history? It's because 1948 saw the creation of the British Nationality, the birth of the British Nationality Act, which created a completely new status for people who were formerly subjects and chose to retain this connection with the UK, and which was the citizen of the UK and colonies, CUKC, as a status. And what the 1948 Act did was it allowed anyone who is a CUKC to then come and reside in the UK and do so, without taking any steps. It simply declared that they have the right to come and reside and work and whatever. It declared it as a matter of right. And it's not that it was a big change. Actually, in times of empire, people could travel. In theory, they had free movement. In practice, it was difficult to travel from colonies to dominions because there were much more race and ethnicity linked bars on people. For example, there were head taxes, which people had to pay if they came from certain parts of the world. And so there were other limitations placed, but in theory, they could, as subjects, travel throughout empire. So why did suddenly this declaratory provision, which is really seems quite like an opening of doors, why did it come about? And historians have looked quite closely at this, and they see that it's linked to what was happening in the dominions at that time. So Canada, for instance, is a really good example. Canada had started making its own nationality laws, despite being a dominion at that time, and it was giving preference to its own French-Canadian nationals, as well as others from other dominions, but restricting people who were coming from erstwhile colonies. And there was a specific provision in Canada which said that actually British subjecthood is dependent on being a Canadian citizen. And so suddenly you see there is a change in this balance of geopolitics, whereas previously other nationalities were deriving their authority from British subjecthood. Suddenly this is now reversed. You first have to hold the nationality of other places like Canada, and then. So this was seen as subverting the importance of British subjecthood and Britain in the world's geopolitics at that time. It was just post-war, the colonies had taken part in the war efforts, and there was an understanding that there would be special relations maintained. So we see in the backdrop of that then, special status given, and which is the citizen of the UK and colonies, where people can come and reside and work here. There was also active recruitment, lest it look like it was simply a matter of opening the doors. This was about building post-war Britain as well. And there was active recruitment to come and do that. And there were posters which were like, come help the motherland and, take part in building up Britain, things like that, which were happening simultaneously. Now, very quickly, this goes completely in the opposite direction. A very famous speech, which Powell's Rivers of Blood speech, I will not read the whole thing, but I think this captures this last, I won't even read the whole thing for you, I don't like to, but this last sentence, it is like watching a nation busily engaged in building up its own funeral pyre, in heaping up its own funeral pyre. I think it's really strong imagery, which shows the distaste for, especially for migrants and their descendants coming. So the idea that somewhat the demographic configuration will change and worry about that is very clearly demonstrated, I think, in this speech. But there were numerous other developments of a similar nature. This is just one of the better known ones, which was happening after people had started coming in. So I'm reluctant to say people started coming in only after 48. In fact, there's evidence to the contrary, but I think there were more arrivals at the same time, which became quite high profiles. For example, the Empire Windrush ship arriving. So it became better known around then. So another example then is the experience of people when they did arrive here was not quite the open and welcome one of the 1948 Act. And instead, they were met with various signs like this when they tried to rent or look for jobs. And it was not a very a positive experience for many people. So together with that political rhetoric, you could see that there was a changing tide as well in the immigration law scenarios. So I will not take you through the various pieces of legislation that happened, but I'll talk about two key ones because these two are really critical for understanding what happened to the East African Asians and why they struggled to enter the UK, because with the 1948 Act, it looks like they should have been able to come in. What had happened was there are two key pieces of legislation. The 1962, the Commonwealth Immigrants Act, it just removes the right to enter for people from the Commonwealth. And they say that if your passports have been issued by colonial authorities, there will be no associated right to enter. So what do we mean by colonial authorities? So it's the British government, but the British government, let's say in Tanzania, or the British government who was there in place in Uganda, they issued that British passport. That will not be linked to a right to enter. The statute removes that. Now, immediately it means a lot of people who held British passports, which were issued by their colonial British governments, no longer could use that passport to enter. So it changes that 1948 Act significantly in terms of what practical use it is for people. Then in 1968, we see a different clause added, that it says that people can live and work in the UK, Commonwealth nationals, if they or at least one of their parents or grandparents had been born, adopted, registered, or naturalized in the UK. Now, seems quite neutral, race neutral on the face of it. But if you think about it, people who are in the colonies are really unlikely to have a parent or a grandparent who are born within the geographical limits of the islands of the UK. Whereas people in the dominions are settler societies members, they are likely to have a grandparent or a parent who has been born in the geographical limits here. So the effect of these is really to exclude people who are in the colonies, who are ethnic minorities, and then who cannot use that 1948 open provision, declaratory provision anymore. So these two then work in tandem to really restrict the right of entry of Commonwealth nationals. And at this time, we have various people who hold British passports, who have retained the CUKC status, and who are in newly decolonizing countries. So here, specifically in Africa, we can look at East Africa, countries like Uganda, Kenya, all of these. We have changing regimes and changing governments, whereas there are many people who still have British passports there. So we get our first major story of what happens. What happens is that the Asians in East Africa, who were always worried about what will happen to them because they will become minorities, and who were concerned that they may not be treated fairly, suddenly find that their businesses are being closed down and they're being told that, you know, just leave, or find ways to do other work, which is more menial. So their quality of life really went down. So they held the British passports that they had, and they wanted to enter here with those passports. At that point, they come up against this new legislative frameworks, and they are put in detention. They're sent to other countries and put in detention, and many of them are just denied entry. And here is the question, is this about nationality as a right? Is it about the British passport? Or is it about asylum seeking rights? Because they are definitely fleeing persecution as well. So we see the conflation of the two. Or is it just a much more general basic human right framework? So the questions then come up before the European, at that time, the European Committee, the Council was actually a court status holder and looked at it. It was not simply looking at prima facie, but actually heard the whole set of arguments, looked at the situation of the East African nations, and decided the case mainly on the issue of violation of Article 3 on the basis that this is inhuman and degrading treatment. And it is linked to race because only people of certain racial configurations are not able to use their right to nationality linked to holding a British passport. And they then look into that from Article 14, prohibition on discrimination in the European Convention. But what we do not find in this judgment is any major pronouncement of what nationality right is. What does it actually entitle you to do? We get a scheme according to Article 314 and a few pronouncements on right to respect for private and family life and right to liberty, a little bit on what holding a passport means, but not a very substantive judgment on that. Nevertheless, it's really significant as having found a racial element in this. And the UK government did respond to it and changed its scheme to something called the special voucher scheme, which it started giving to male head of households. That's another story. I'll tell you some other time. But it did respond to this and created some changes, which is a good positive outcome, I think. So another reason to look at the 1948 Act and think about consequences relevant for today's time is, of course, what's happening with the Windrush generation. Most of them are from that period when the law was merely declaratory. They didn't need to register or get any documents to prove their status. In fact, evidence of them boarding the ships or having traveled on them, especially if they came as children, didn't either exist or in some instances had just been lost or burnt or things that happened basically over the passage of time. So they're fine, they're living here, they have lives here. And then we suddenly get a whole spate of legislation, which were initially known as the hostile environment legislation, but get repackaged as the compliant environment legislation. But the net effect of which is that you have to show your documentation to various people, employers, landlords, even sometimes medical treatment, though there has been some back and forth on that, universities, all sorts of places. Suddenly you need to show all these documentation. And the Windrush generation, people not just on that ship, but who are actually Commonwealth nationals who were under the 1948 Act and beyond, their children, they don't have these documents. Many of them then get wrongfully deported. So I think of this as, here is a person, until this is absolutely one of us, they belong, they're part of the society, they're not foreign in any way. Overnight, suddenly, you find they are deported, they're sent away, and they don't belong anymore. So it's a radical shift in status from being a national, being a member of society, to becoming an irregular person. Of course, there have been apologies made, and for the mistakes, there is a scheme to give compensation. The scheme itself requires a lot of administrative documentation and has come up for criticism, has paid out very little in terms of compensation. There's a separate status scheme which actually looks at people and how to give them some documentation, again, requiring some other proofs from them. But there are measures to now rectify. There is an acknowledgement that something went really wrong here. So again, so coming back to my discretionary point, everybody who had all these things as a matter of right became dependent on administrative discretion. And even with the scheme and compensation, etc., it still is an administrative process of decision-making on a case-by-case basis rather than the broad-based right that was envisaged before. So we cannot talk about settled members suddenly becoming irregular without talking about the Brexit situation. And here I'm going to talk about a specific case, which is the latest one from the High Court, actually, which is about the EU settlement scheme and how people who had pre-settled status were treated under this scheme. So pre-settled status meant that somebody hadn't yet resided for a full 5 years, but they are an EU national who had taken some steps already to acquire this status, the pre-settled status. And the expectation was that after 5 years, they would proceed to settled status. However, what happened is that because of Brexit, while there was recognition of their rights in the withdrawal agreement, many of them found that the pre-settled status, the number of years under it, doesn't count anymore towards the settled status number of the 5 years, the clock will restart. And so if they're less than 5 years, or if they've left the country for some reason, then it's even worse because they have to re-enter and do the whole process. And they have to take this step again themselves as an administrative step to get that measure restarted. So the pre-settled status in effect doesn't hold much value unless you've done something else to make that a settled status and your time period starts running. So this was challenged by the Independent Monitoring Authority, and the High Court found that this does not respect the rights of EU nationals as agreed under the withdrawal agreement. The government has agreed, and this is being changed. I don't think, I've been searching all the time, I haven't found, if anyone has found, I don't think it's been changed yet, but there are definite assurances that it is going to be changed, and that affects at least 2.2 million people who are in that category. But the amount of discretionary nature of power coming in when you have to be taking these type of administrative measures again and again, I think that shows the kind of control that can come in when it's not a safeguarded right for people. And again, if someone was a settled member of society, they were a valued member of society, suddenly the risk is after this, they become irregular if they haven't done. And it's affected quite a few vulnerable EU nationals who've lived for many years in the country, but may not have, again, the correct documentation that is required under the compliant environment legislations. So we can see how, in a way, each of these, because sometimes when I read these debates, it seems like it's only these group of people, and then there are some other group of people, and they're all in conflict somehow in their rights and responsibilities. But actually, the legal measures don't work like that. There are connections between what's happening to different people in different periods of time from different backgrounds, but who are arriving to become members of our society here. So it's important to see those connections and think about them. Okay, so I'm going to come now to something that I put in, especially because I'm talking to an audience in Northern Ireland. However, I'm aware that you were all probably more familiar than me on this, so do feel free to correct me. And this is about the renunciation of British citizenship. Why I'm talking about this is because I spoke about Brexit. And prior to Brexit, the EU family law, family permit system actually was more favorable for EU nationals to bring in their third country national family members, because they could come in on a family permit system, and the EU national does not need to then show the minimum income requirements or any other immigration requirements for bringing in their third country nationals. Why is this so relevant for Northern Ireland? The Good Friday Agreement recognizes the right to identify as Irish, British, Irish and British, or maybe neither. I don't know about the neither part really, but it does give you the range of options about identification. And in this context, if you identified as Irish, the Irish Constitution had actually made provision for this. You could potentially then use the EU route to bring in your family members, whereas the British Nationality Act attributed Britishness at birth. And if that came in, it caused some confusion. So I think the case is the Emma D'Souza case, in which she had opted for Irish nationality. The British government said, you've got British by birth. However, it's attributed, and that confuses matters. You can't really go down this unless you give up the Irish nationality. So this resulted in a spate of renunciations of, I saw the data on this, and it was quite striking how many renunciations of nationality, British nationality, took place here in Northern Ireland. And I saw newspaper reports that this was across, it was no longer about identifying or not. It was literally about how do we get out of this and bring in our family member who can come in otherwise. So it was about the practical issue. So not surprisingly, the discussion has been, why do we put people in this situation? There shouldn't be a practical difference if it's a matter of identification and the cultural heritage rather than, which route. In theory, it should be possible to enjoy your rights no matter which route. Now, interestingly, the process of renunciation is quite complicated, again, quite bureaucratic. It involves forms, fees, etc. Now, with Brexit, because it's not going to make substantial difference, a lot of people want to rejoin and regain their British nationality, which again involves another bureaucratic process of reapplication. And anytime you reapply, it's a discretionary process. So you can be denied, although in theory, perhaps not, but it requires fees, paperwork, and it's discretionary. It's no longer a matter of right. So essentially, we've had the steps now, bureaucratic steps of making people choose, because what the Good Friday Agreement has said is not really what's happening with the operation of the British Nationality Act. Now, Parliamentary Committee has advised this should be changed. You need a far more bespoke kind of a provision for Northern Ireland. There have been talks about it. So far, I do not think they are going to change it, especially because the scenario has kind of changed with the Brexit scene now. But it's interesting, again, because attribution of nationality at birth creates problem in a vast number of scenarios. So here we can see this in the context of, showing, being able to choose whether you're Irish or British or both. But more generally, this attribution of citizenship happens in the context of foreign nationality. So British courts could look at a person and try to determine, as a matter of private international law, so as a matter of fact, really, whether they hold another nationality. And often they do that by simply looking at if it can be attributed through their nationality legislation or practice. And that's an entire fact-finding process. And it's not just relevant for this, it comes up very often in the next big topic, which I'm going to talk about, which is cancellation of citizenship. So cancellation of citizenship is connected to the other, again, interstices of who belongs, who's foreign, who suddenly becomes foreign. And in cancellation of citizenship, you could have it for a number of reasons. You could have it for fraud, which actually includes misrepresentation and statement of lies, usually applicable for naturalized citizens and when they apply. But it can also happen for conduct. And conduct can be anything that is conducive to public good. So it's a broad standard. If it's conducive to public good, it might be something that, in terms of the conduct, might be an issue that somebody might be stripped of their citizenship. So I shall come to the attribution of citizenship in a bit, hold on to the thought, but I want to show you how the power has increased. After 2017, where we can see the spike, we don't have data on deprivation for conduct. We do have some data on deprivation for fraud, but it doesn't give the whole picture. So there are estimates of, hundreds of people have been stripped of citizenship, mostly in Syria, and many of them wouldn't have appealed. So we don't really have all the facts and figures. So this is what's concrete, and I've put it, but I've seen estimates of 700 people in the last few years and things like that. So it's a power which was not really, it was present up in the post-war regime, but was not really used until 2002. And after that, it started getting used more in the context of people moving to Syria to become foreign fighters. So that's where you see this power being used. What are the problems with this? In terms of the restrictions, if we think about the international law aspect of the rule of law, the first premise that is important is people should not be rendered stateless because of citizenship stripping. There are two relevant conventions for this. The UK is a signatory and of both of these, but the main thrust of these is that that a government should not increase statelessness. Okay, so how is then this compatible with the use of this power? So this is the relevant section, and this is an amended section. From 2015, we have this section. Before 2015, it was not possible to strip anyone and make them stateless. So they had to have one surviving nationality if the British citizenship was being taken away. And that's where the cases were all about, is there a surviving nationality or not? And then there was fact-finding about what is that other nationality by looking at that other country's legislation and treating that as a private international law matter. So that's where the case law was. But often it would be that the person is a naturalized citizen and they do not have a surviving other nationality because the other country's legislation says if they get any other nationality, this doesn't survive, or it was very difficult to prove that they actually have a surviving nationality. So what we see then is an amendment in this context. And now it is possible to strip a naturalized citizen of their British citizenship and render them stateless. Okay, so the actual provision there, it's a higher standard. It's not just about what is conducive to the public good. It has to be seriously prejudicial to the UK's vital interests. So it's a higher standard. And the Home Secretary has to have reasonable grounds to believe that the person could acquire another nationality. So the critical thing there is they do not need to actually hold another nationality, but there is a possibility that they can acquire another nationality. That is sufficient. Even these two safeguards about seriously prejudicial to UK's vital interests as a higher threshold and the reasonable grounds were actually introduced in the House of Lords as potential safeguards. The original clause didn't include that. So through this, what emerges then is a very interesting picture. Depending on where you were born and how you became a national, and whether you hold another nationality or not, you may or may not be rendered stateless through the use of this power. And the only category who can be rendered stateless, whether or not they have anything else, is a naturalized citizen who does not have any other surviving nationality. Now, this is absolutely gobsmacking in a way because we have never seen differential citizenship rights operating in this manner with different effects for different categories of citizens. So I think the question was even asked in Parliament that do we have this in any other operation of law? And the answer was not really, but we've had historically powers to strip naturalized citizens only. So there has been differential use of this particular power. But nevertheless, I think it causes some reflection. Also, I'd like you to note here that if you're born in the UK and if you do not have any other surviving nationality, then you definitely cannot be stripped of citizenship. However, this is a small category because it's possible to find a link with some other country. It could be through some other country's legislation, right? So let's think about Israel and the right to return. Maybe let's think about generous provisions of nationality through ancestry, maybe even Ireland prior to changes that happened. But there are various instances we can think of. This might be quite a very small category of people who cannot be stripped at all. Right, and so I've given you a quick timeline here. I won't talk about it that much. The last significant development has come into effect this month on the 10th of May, which is a provision from the 2022 Borders Act, which says that if it is significantly difficult to give notice about cancellation, it's not required to give notice, but it will be scrutinized by judicial order. So that is a change that's happened. So very quickly, the Bingham case has brought cancellation powers really to focus of the national imagination. And we've had two judgments of the Bingham case, which are the latest two, one from the Supreme Court and one following that from the Special Immigration Appeals Commission. The Supreme Court judgment was limited to whether she can come back and participate in the appeal in the SIAC, the Special Immigration Appeals Commission, and the Supreme Court said, no, she cannot do that. There has to be something to provide her access, but Article 10, right to fair trial rights can be protected in other ways, and she doesn't need to be allowed to attend. And then the Special Immigration Appeals Commission, after that, proceeded with hearing the appeal and found that she is a significant risk to national security. And we don't know the reasoning for it because that is in a separate closed judgment. What we have before us is the open judgment. The open judgment says that the facts in the closed judgment have been duly presented and considered, and she is a risk. Now, this is the case in which the issues of trafficking were raised, and the fact that she was 15-year-old when she had traveled, the fact that there was a Canadian intelligence officer involved in this, in the mix, which we now know after some investigative journalism. What does that mean for a trafficked minor? And the SIAC has actually said this, and this is a quote from the judgment, that there is credible suspicion that Bingham had been trafficked for the purpose of sexual exploitation. And it found there were arguable breaches of duty by state authorities in having allowed her to make the journey to Syria. Nevertheless, that does not really hamper with the calculation of the national security risk presently from Bingham, which is what the case is about, dealing with her as an adult and as a present scenario that then said that she should not be allowed to regain her British citizenship. It's not the end of the matter. There will be challenges to this, but this is where we stand with this right now. And I find this an interesting quote from it, so I'm presenting this to you. The SIAC decision says many right-thinking people in the country's Muslim communities and beyond feel they are being treated as second-class citizens and or that their welcome is somehow contingent. And then it says this issue is of concern, but it has been considered, and it's been considered by the Home Secretary, and it's in the closed judgment. So we can't assess it for ourselves, but we do know that it was in the minds of the judges, and they have looked at it. So it's very difficult then to really assess how this power operates in practice. So to come back to my rule of law principles and the international law elements and the wide discretion, the Home Secretary's discretion in this area in determining these two standards of conduct is really wide. The SIAC has, when it has tried to look into how far this discretion should be, in fact, it has heard from the higher courts that you cannot step into the shoes of the Home Secretary. It's their decision. You can't reassess everything. So they're very limited in what they can look into. So there is quite a bit of latitude here with the Home Secretary, which of course they have to exercise in terms of good faith as another principle of rule of law. But the other thing is the avoidance of international law duties here. There's an issue of trafficking, statelessness, provision of fair trial by being present in your own trial, but also the closed materials proceedings and having special advocates has often come up as an issue as well for the Special Immigration Appeals Commission. And I would add to this the various tiers of nationality and what does that do in terms of community relationship and trust from communities, if that has come up even in the SIAC decision, but I'm not sure it's been adequately, we have adequate information on it, that is. So these are all, I think, the connected rule of law issues here. So I've already spoken about some of the challenges of defending the rule of law. If it's in a closed materials proceeding with special advocates, there are special challenges there. But recently, apart from these, there are also serious concerns about the kind of statements that are made by very senior politicians. I shall not name names here, but it's widely reported about the role of lawyers and then subsequent attacks, physical attacks on lawyers by extremists. So people actually, someone went into an immigration law firm and wanted to go for somebody because they were representing asylum seekers. So there's actual fear to the lives of lawyers who take on these cases. So this is, I think, a severe challenge now for defending the rule of law or talking about these issues for your clients if they are the ones who are unpopular or who are being represented in these scenarios. So I think it's not that it's the same story from colonial days to 1948, because I've given you a wide variety of examples, but it's not like it's the same continuous story. There are many trends, there are many new directions. I'll just mention two briefly. One is that it's possible to think about now the change in ideas of jurisdiction. Previously, through the Calvin case particularly, it was possible to see an extension of jurisdiction through the bodies of subjects. So the king's jurisdiction and the presence of the subject where they are actually extended the jurisdiction of the state. And that was one of the kind of holdings of the Calvin case, which was very much applied in the context of settled territory. For example, when the US became a settled territory, this was a principle that extended the king's jurisdiction here. But if we look at the cancellation of citizenship cases, what we find is if the citizen leaves the jurisdiction, and in almost all the instances they are stripped of citizenship once they leave the territorial jurisdiction. So there is a roll back from the bodies of citizens when they leave, and the roll back from the territorial connection. And this is, I think, a new trend. And the other element is pervasive bordering. I haven't talked about it today. It's a whole different topic, but it's sort of the compliant, the environment idea of individuals being involved in bordering, people checking documents. So that's not so much about just the physical borders, the checkpoint at the airport or at some physical border location, but people being drawn into this so that bordering is in more locations. And this, I think, is much more of a new direction or trend. So I will end now with one of my favorite poets whose permission I took for reproducing this, the poet laureate of Arizona. And in this sonnet, it says, the border used to be an actual place, but now it is the act of 1,000 imaginations. And I think, yes, some of these powers and the way they operate with people, it has become really different use of this power. But we can see still some of the conceptual links with the past. I will end there. I would love to expand on anything in questions or just chat with you more, but I think there's a lot there already. So this will be where we stop for now.